Hey guys, this is Christopher Kitchens. The two cases that I decided to dive into were the Rule 1.3 case, Matter of Woods, and the Rule 2.1 case, the Harrison case. So I'm going to start with the diligence case, Rule 1.3. So to go to that citation. You're seeing how slow of a typer I am. Typist. There we go. All right. So, brief summary of this case. In this case, attorney David Woods, in February of 1984, takes on a case representing John and Tina Robinson. It's a personal injury case against the city of Anderson, Indiana. Upon getting the case, he starts negotiating with the city's insurance. In June of the next year, the underwriter for the city's insurance company asked him for some medical documentation, and all he sends him is this handwritten note with expenses on it. And then they ask him for more info, and he just stops responding altogether. Then in July of '86, Anderson determines that the city of Anderson determines that he has that nothing's been filed on behalf of the Robinsons. So by this point, they were already beyond the statute of limitations. The Robinsons don't even find out then. They don't even find out for more than a year later that nothing's been filed on their behalf, and that the statute of limitations has expired. So, turns out Woods never filed a complaint because of a conversation that he had with Mrs. Robinson about her bankruptcy, which they started. It seems that they started around the same time that they started talking about the personal injury case. He told her she couldn't do a no asset bankruptcy with the pending personal injury case. And so she said, well, she wanted to proceed with the bankruptcy, which he took to mean that she wanted to drop the personal injury case. So he didn't communicate that to John, though, the husband, and he didn't adequately communicate that to Tina. So she didn't understand what he was doing. He just kind of took that as an implication that he should drop the personal injury case. So he didn't do anything with it. So after that, they are continuing on with the bankruptcy. The personal injury case is no longer an option. And so they're continuing on with bankruptcy, and he said everything was taken care of, but their case was dismissed shortly after. And then Wood said he would pay for a refile, but he wasn't aware of a 6-month rule that you couldn't file a petition for bankruptcy within 6 months of a previous one. So when he found out about that rule, he never he never told the Robinsons. He just kind of left them hanging. So when everything came to a head, in August of 1987, the bankruptcy court dismissed Robinson's petition for bankruptcy. Like I said, they weren't able to refile, and so a complaint was filed several years later against the attorney, Mr. Wood, under the Rules of Professional Conduct 1.3. Now that is the Indiana statute. So comparing that with and this is the wording in the Indiana statute, it requires an attorney to act with reasonable diligence and promptness in representing a client. So obviously we know that he decidedly did not act with reasonable diligence and promptness in representing a client. His lack of action in the civil case, left them basically in a situation where they couldn't do anything with it. And his lack of action in the bankruptcy case and his delaying there caused that to be dismissed as well. So he just basically left them on the hook with everything. Now, seeing how that matches up with our rule in the Tennessee side of things, gonna find that one. Okay, one more. Okay, so the Tennessee rule says is a lawyer shall act with reasonable diligence and promptness in representing a client. Pretty much identical. And so, yes, by the Tennessee rules, I think that he still would have been held. The same ruling would have. Oh, this is the syllabus. This is the wrong way. The same ruling would have been upheld even in Tennessee. So, going to the next case. All right. Harrison, so all right. With this one, in this case, David Harrison takes on a client for a civil case involving an auto accident. So it's an auto accident suit. So he has this case for over 4 years. Over the course of these 4 years, he only meets with this client 3 times. And each time that he meets with this client, the client is initiating contact. So pretty terrible standard of care to begin with. So it turns out that Harrison had learned within 3 months of accepting the case that his client's doctor did not support the contention that the client's injuries were caused by the auto accident. So he had this information for years. So with that information, he never has a conversation with them about the merits of their case. So, and then after these 4 years, when everything comes to a head, he tells them very delicately that they would be laughed out of court if they were to if they were to try to go after this. So this is after 4 years. So he obviously knew that their case lacked merit for this entire time, based on his conversations with her physicians, and did nothing with it. Never informed the client of anything that was going on, never told them that their case lacked merit. So there are several rules that we see that he violated. But specifically, we're talking about Rule 2.1, that's the assignment. So in representing a client, a lawyer must exercise independent professional judgment and render candid advice. So first of all, did he exercise independent professional judgment? Well, yes. The problem is this part, that he never rendered candid advice. He obviously exercised independent professional judgment because it was his judgment that if they were to bring this before a court, if they were trying to try this case, that they would be laughed out of court. So he obviously had determined and judged that it lacked merit. The problem was that he never conveyed that with his client. So that he, under the rule of South Carolina, under the statute in South Carolina, yes, he very obviously violated the rule. The question is, does this match up with Tennessee? So let's go to Tennessee. Statute 2.1, they are the same. Same number. Here we go. Okay, so in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. So that's the part that we see quoted in the case. So it also said in rendering advice, a lawyer may refer not only to law but other considerations such as moral, economic, social, political factors that may be relevant to the client situation. So none of that was really a problem. The main problem was specifically in terms of law, whether or not they'd be able to effectively and successfully try the case. So based on what we see, based on the Tennessee statute, yes, I would say that the same judgment would have been upheld, at least as it relates to Rule 2.1.